Good afternoon, and thanks very much to each of you for taking the time out of your busy day to attend this Rahman Ravelli webinar. I'm Aziz Rahman, Senior Partner at Rahman Ravelli, and I will be your moderator today. We at Rahman Ravelli and our fellow panelists have been particularly busy regarding sanctions in the wake of Russia's invasion of Ukraine in February. Sorry about that. Representing conglomerates, corporates, and designated persons in high-level cases. That is why we thought sanctions would be a timely subject for a webinar. So since the invasion of Ukraine, the UK has sanctioned more than 1,000 people and over 100 businesses, including oligarchs, worth a total of £117 billion. Imports from Russia are now at the lowest level since records began. A quarter of a century ago, with no fuel imports from Russia for the time since records began, and exports are dropping. Meanwhile, the EU has so far frozen 13.8 billion euros worth of assets held by Russian oligarchs and other sanctioned individuals and entities. And the Russian elites, proxies, and oligarchs task force made up of representatives from the US, the UK, Australia, Italy, Germany, France, Japan, Canada, and the European Commission is said by the US Department of Justice to have blocked $300 billion in Russian central bank funds from circulating. It is a time, therefore, when many corporates and individuals are needing advice about the nature, structure, and application of sanctions in one or more jurisdictions. They also need guidance regarding their status in those jurisdictions. So determining whether a designated person can be considered to have ownership or control of an asset can be of critical importance to a company and its shareholders, parent company or subsidiaries, as well as to any related trusts and trading partners. So it's an appropriate time to bring you our webinar, which we have called Navigating Russian Sanctions, the Lessons to be Learned. In the next hour or so, our panel will be examining a number of important sanctions issues, most notably navigating UK, EU, Swiss, and US jurisdictions, assessing the impact of having a designated person within the structure of a corporate, applying for a license to conduct activity prohibited by sanctions, as well as how to report sanctions-related matters to the authorities, manage the effect of sanctions on business and professional sectors, and assess and mitigate the risks facing law firms handling sanctions matters. So these are extensive subject areas, and we'll endeavour to cover as many as possible. After our panelists have addressed the various topics, they will take questions from you for approximately 15 minutes. Please feel free to post questions on the function provided on the Zoom platform. So the webinar is being recorded, and the recording will be made available in due course. Before we go any further, I should introduce you to our panelists. So they are Salome Lemasson of Counsel at Rahman Ravelli, who will focus on EU sanctions. With extensive cross-border experience, Salome leads Rahman Ravelli's EU business crime and regulatory practice group. She has in-depth knowledge of various countries' legal systems and regulatory regimes, and is particularly active in the field of sanctions. Then we have Eric Ferrari, partner at Ferrari and Associates, who is here to explain the United States approach to sanctions. As the founder and principal attorney of Ferrari and Associates, Eric frequently represents clients before the United States Department of the Treasury's Office of Foreign Assets Control, Lfac. He has over 13 years of experience in national security law, exports control, and US economic sanctions. Then we have Carla Reis, partner and attorney at law at De Goots and Associates, who will give us a Swiss perspective on sanctions. Carla has extensive cross-border experience, and she will draw on her 15 years practicing in business crime, international mutual legal assistance, and corporate investigations, as well as her knowledge of compliance, regulatory matters, and sanctions. And finally, we have Zulfi Mirza, Senior Associate, and Rahman Ravelli, who will detail the UK sanctions stance. As a member of Rahman Ravelli's sanctions team, he uses his comprehensive knowledge of the UK regime on some of the most notable sanctions cases. Zulfi is also a former serious fraud office prosecutor and specializes in multi-jurisdictional corporate crime. So that's our panel for today. Before we make a start, let me just draw your attention to the fact that we intend to use diagrams and talk through fictional cases to explain and illustrate some of these issues. You'll have already received these diagrams in advance, but don't worry, there's no requirement to have studied them. Anyway, that's the formalities out of the way. Let's get down to business. When it comes to sanctions, any business or individual with connections to a designated person needs to be assessing their situation very carefully. So with this in mind, we will consider our first topic, which is how does the presence of a designated person impact my business? So diagram 1, please, Tom. Just 1 minute. Thank you. So when a designated person appears on a sanctions list, it is clear that their assets are subject to freezing, but sanctions cover all assets that such a person has ownership or control of, and there can be various variations from jurisdiction to jurisdiction. That's exactly what constitutes ownership or control. With that in mind, panelists, can we consider, by reference to diagram 1, what are the key considerations in relation to establishing ownership and control or control by designated persons across the corporate structure? And what impact does the presence of a designated person have? So let's start with Zulfi. Can you please talk us through the diagram from a UK perspective?
Yes, thanks Aziz, and thanks, hi everyone. So as you can see from a UK perspective on diagram 1, you can see that PEC Limited is the UK incorporated entity, is 100% owned by a Russian entity called JSC Pushkin, and that Russian entity is then owned by Ms. Volkov in a 30% shareholding and Mr. Fedorov in a 10% shareholding. Both of those individuals are UK sanctioned. So in terms of the first step, as PEC is not designated, financial sanctions from a first step don't apply. We must then look at whether PEC is actually owned or controlled by a designated person. And if so, they would then be caught by the UK sanctions regime. So just give you a brief overview of the law. In the UK, it's Regulation 7 of the 2019 Russia regulations, and OFSI guidance sets out the conditions for establishing ownership and control. For those of you who don't know who OFSI are, they're the Office for Financial Sanctions Implementation, and they're the authority responsible for implementing the UK's financial sanctions. So just looking at the conditions for ownership and control, either of these conditions can be met or should be met, and they are, first of all, that the person holds more than 50% of the shares or voting rights of the entity, or holds the right to appoint or remove a majority of the board of directors. The second condition that applies is that the person is able to ensure that the affairs of the company are conducted in accordance with their wishes. So the first condition is quite straightforward. In relation to the second condition, there are a number of factors. I'll call them wishing factors. And just to give you an example, they are if a person is able to appoint a majority of the member of any function, for example, administrative, management, or supervisory function. So practically speaking, this could be a HR or compliance function. So if we quickly look at diagram 1, you can see that from a UK perspective, ownership is not established through the shareholding of Ms. Volkov and Mr. Fedorov, as they each own less than 50% of Pushkin. We must therefore look at control. And the best way of summarizing this is legal and actual control, or de facto control. To do this, you have to really do a due diligence deep dive and really understand the complete factual picture. This will include things like reviewing articles of association, having a better understanding of the relationships within the company structure, and also reviewing things like board minutes to see what is being discussed and whether the wishes of Ms. Volkov or Mr. Fedorov are being taken into account, and also whether they sit on subcommittees, etc. In the circumstances where ownership and control is established, then the assets of PEC must be frozen within the UK. A license would then be required to allow an act that would otherwise be prohibited. I think the key takeaway point from the UK perspective is that when it comes, is really in relation to divergence from other regimes on aggregation, in that OFSI don't aggregate shareholding when it comes to determining ownership. So what does that mean here? If Ms. Volkov and Mr. Fedorov each hold less than 50%, and there's no evidence of a joint arrangement between them, then PEC is not owned by a designated person. Of course, you will then have to look at control separately. Thanks, Aziz.
Thank you. Salome, can you please outline the EU's position?
Sure. Thank you very much, everyone, for attending this webinar. I think the EU and UK regulations are very similar in so many ways, but there are some divergence that is interesting to point and to keep in mind. First of all, when you look at the diagram that we've prepared, you might wonder what we're talking about EU regulations when none of the entities are EU incorporated. The reason being that EU sanctions may apply to non-EU incorporated entities when they perform all or part of their business in the EU. And here, this is exactly the case for UK incorporated PEC Limited, which is conducting part of its business in the EU and as such qualifies as an EU operator. So that's why it's important for businesses to consider all the sanctions regime to make sure that they comply with all of them, not just focus on where they are incorporated. The second aspect to keep in mind in terms of EU regulation is that the EU looks at both ownership and control, so similar to the UK, but contrary to the UK, we look at aggregations. So here we would look at who owns PEC Limited, so the Russian entity, not sanctioned, but who are the beneficial owners of that Russian entity. And here we see two individuals that are EU sanctioned, Ms. Volkov and Mr. Fedorov. And so what we need to look at is, do they jointly own more than 50% of GSC Pushkin? So thankfully for us in our diagram, they are just below the 50% threshold. And so that's when we move to the next question, do they control in practice, whether legally or in fact, actually GSC Pushkin? And here the elements to look at are similar to the guidance implemented by OFSI. We look at many different factors that would suggest control, so having a decisive influence over the business or sharing financial liabilities, any criteria that would sort of suggest that there is control by the EU designated person. And as soon as one of the elements is established, and that's very important to keep in mind, there is an assumption of control. This is, of course, a case-by-case analysis, and so this assumption can be rebutted, in fact, if you can prove that actually there is no such control. But as you can imagine, it is going to be rather difficult to prove that. So it's definitely something to monitor. And so if we were to establish here in our case that Ms. Volkov and Mr. Fedorov actually control GSC Pushkin, then it is likely that PEC's asset would be treated as, controlled by EU designated persons, and so that its asset should be frozen. Thank you very much.
Thank you. So Eric, please talk us through the situation as regards the US.
Sure, absolutely, and thanks for having me, and thanks for everyone who's in attendance today. The analysis is slightly different here. There are some nuances that need to be kept in mind. And what we're going to primarily be focusing on is application of what we call the Lfac 50% rule. The 50% rule, I think it's important to note, is a rule of constructive blocking, meaning entities can be blocked regardless of whether they appear on the specially designated nationals and blocked persons list. That's the US sanctions list. And it relates to ownership of the entity. And the ownership interests are by aggregation. So here we're assuming that Mr. Sidorov is sanctioned under a what we call a blocking program, because there are different types of sanctions programs. And since we're talking about Russia, let's just assume it's under the Executive Order 14024. And since he owns 60% of JSC Pushkin, although that has not been an identified entity, has not been expressly designated, it is considered what we call constructively blocked. So for all intents and purposes, it is deemed to be a sanctioned entity in applying the prohibitions of the sanctions regime. One note before I move on to Hitchcock's position as a result of Mr. Sidorov's indirect ownership, which is that U.S. designation criteria within the executive orders allows for the designation for ownership or control by an entity. So this is different than whether the prohibitions automatically apply, and instead creates exposure for those entities owned or controlled by sanctioned persons. So if we were to take a step back and reduce Mr. Sidorov's percentage down to 40%, JSC Pushkin wouldn't necessarily be blocked because the ownership wouldn't rise above 50%. However, JSC Pushkin would be exposed to a designation for ownership or control by Mr. Sidorov, which could then impact a risk calculation as to whether to do business with them or indirectly to do business with Hitchcock. So I just wanted to make that side note because I think it's an important distinction to keep in mind. With respect to Hitchcock Incorporated being a U.S. entity and having this indirect ownership, 50% or more by Mr. Sidorov, it would be considered blocked. There's an interesting question as to whether you treat it as a blocked person or blocked property. I think the answer is both, but for all intents and purposes, it wouldn't be able to engage in any business other than that which would be licensed by Lfac due to the blocking. And in similar situations, because this scenario has come up before, Lfac, what we've seen Lfac license is merely those activities related to maintaining the entity as opposed to carrying out its business or doing any new business. So that's the U.S. overview with respect to this diagram.
Thank you, Eric. And Carla, can we have the Swiss perspective, please?
Yes, of course. Well, hello everyone, and thank you also for having me. Thank you for the attendance. In Switzerland, well, according to Article 15 of the Swiss Ordinance, are subject to asset freeze assets and economic resources owned or controlled directly or indirectly by a designated person. You can see in diagram 1 that Verbier SA is a Swiss incorporated and is 100% owned by its Russian parent company, so JSC Pushkin, who is owned 30% by Ms. Volkov and 10% by Mr. Fedorov, both of whom are Swiss designated. As Verbier SA is not designated, Swiss financial sanctions do not apply from this first step. We must then look to whether Verbier SA is owned or controlled by a designated person, and if so, they would be caught by the Swiss sanctions regime. So, as of November 1st, 2019, bearer shares are no longer allowed in Switzerland, with a few exceptions, thus meeting the FATF requirements in this respect. For registered shares of a Swiss company, the mechanism already in place is as follows. A person who alone or in concert with others holds at least 25% of the share capital or voting rights of a Swiss company is obliged to notify the company of the name and address of the beneficial owner. The company therefore keeps a list of its beneficial owner in such a way that they can be accessed at any time in Switzerland. So in the present case, considering that 40% of GSC Pushkin, the mother company, are owned, controlled by two Swiss sanctioned individuals, the question is whether the Swiss bank will, as a result, so the Swiss bank of Verbier SA will, as a result, freeze and report the assets of Verbier SA in compliance with Article 15 of the Swiss ordinance. The first instinct of the bank will be to freeze the assets and try to establish legal and actual control of the mother company. I recently had a case involving a company that held assets at Julius Baer that was in a similar situation as Verbier SA, except that the mother company was also another Swiss company. And the bank reached the conclusion that they needed to be cautious and seek guidance and freeze and report the assets because they were over the 25% threshold, and SECO, so the Swiss Secretary of State, confirmed. SECO in Switzerland has not issued specific guidelines on this subject, unlike the EU or the UK or in the US. After discussing with Salome actually this morning, I confirmed that it is nevertheless recognized that some of may refer to the interpretation tools of the EU to interpret the Swiss ordinance, in particular considering that Switzerland is simply aligning itself with internal assumptions and in particular with the EU in this particular case. Therefore, if we successfully demonstrate that Ms. Volkov and Mr. Fedorov do not have effective control of GSC Pushkin, then Verbier SA should be able to keep operating properly. So the 50% rule that my colleagues mentioned earlier will not apply automatically in Switzerland. Verbier SA will need to demonstrate that the affairs of GSC Pushkin cannot be conducted in accordance with Ms. Volkov and Mr. Fedorov's wishes. In the case with Julius Baer that I mentioned earlier, the bank wanted to have an understanding about what were the corporate rules that were applicable to the holding entity. In that case, the holding entity was Swiss, so the 25% threshold applied. But in this case, since we are talking about a Russian entity, it makes sense to seek a Russian legal opinion. So that would be the situation in Switzerland.
Thank you very much, Carla. And thank you, panelists. Now, moving on. Can we have diagram 2, please, Tom, on the screen? Thank you, Tom. So now we come to the issue of trusts. This is an important area, as individuals will often organize their affairs through a web of offshore trust structures, and those structures can ultimately own the corporate entity. The issue is whether designated persons in such a situation can be said in law or as a matter of fact to either own or control the entity in question, meaning that the entity is then caught by sanctions. So this is very often a complicated area and one that requires careful forensic analysis. It involves a multitude of jurisdictions. Each jurisdiction's legislation will require very close scrutiny with regards to ownership and control, and there will be overlaps and conflicts to reconcile. So to be fair, such a wide, complex area is worthy of a webinar of its own, but today we're going to take an overview of it. So here is a diagram of a fictional case for illustration purposes. There's no need to look at it too closely for now. Our panelists may refer to it when they answer my next question. And that question is, in your jurisdiction, what are the considerations to be kept in mind regarding trusts and the issue of ownership and control? So Eric, can we start with you, please?
Sure, absolutely. And thanks for the question. I think there are a few issues that are immediately important when considering trust and where a sanctioned party has either some involvement, some history with the trust or its assets, or some interest. And just dealing with the interest first, you know, in this scenario that we have with Mr. Ivanov, I think the most immediate question becomes what reversionary or contingent interest does he have with respect to the trust and or its assets? If there is some contingent or future interest or potential future interest in the assets, then the trust and its assets can be deemed to be blocked by operation of his own blocking sanctions designation. Again, assuming that the sanctions imposed upon him are blocking or under a blocking authority. And so that is the first and most immediate concern, is really sussing out and understanding what, if any, is his interest. Obviously, here we have him as a settler, so it's not immediately apparent he has any interest, but to the extent that he does, that would be an issue. Another important issue to keep in mind is whether he was sanctioned at the time that the assets were transferred to the trust. Were those assets deemed to be blocked assets, and is the trust merely serving as pass-through for these blocked assets to be moved, or for their ownership or true ownership to be obfuscated? So there's another important issue, and as you noted earlier, a lot of factual analysis needs to go in to examining that and other issues. And then finally, I think it's important to know, what are the assets the trust is holding? Where are they located? What line, if there are entities within under the trust, what sectors are they operating in? All of those questions are important as well, particularly if there is some reversionary or contingent interest. So I know that, particularly over the last year, that the issue of trusts and transferring of assets into trusts has been viewed by some to be a sanctions mitigation strategy or practice, but there are a lot of legal issues that can come up, and there's still quite a bit of sanctions risk analysis and potential sanctions exposure, depending on how the facts play out. And some of the issues I highlighted speak to what factual analysis is needed.
Sure. Thank you very much, Eric. Zulfi, let's have your views, please.
Yeah, thanks, Aziz. So looking at diagram 2 very quickly, you can see from the UK perspective, Mr. Ivanov is the settler, and he is UK sanctioned. And then one of the beneficiaries, Mr. Petrov, a Russian national, is also UK sanctioned. So as Aziz has said, this is probably a seminar on its own. Obviously, trusts, as you can imagine, is a complicated beast. But what we tend to be seeing is that as a settler who is more often than not designated, trying to extricate himself or herself from the trust structure, for example, removing themselves as a beneficiary, you would have to look as to whether they have validly done so, i.e. remove themselves from the trust structure, and if so, do they still actually exercise or exert control over the trust structure? So the best way of looking at this is probably in terms of peeling an onion. You've got to really look at the layers, and your analysis on control should go through each of the layers. So with Mr. Ivanov, you have to look at whether he has any control of the trust itself, and by extension, any of the trustees. This means, because of course, as you'll know, the trustees have their own fiduciary duties. Secondly, once you've gone past that level, you've got to look at whether Mr. Ivanov has any control or his relationships in relation to the management structures or the ownership structures of the trust. So for example, if the trust is owned by a company, who are the directors or senior management of that company? And what is Mr. Ivanov's relationship with them? Does he have any control over them? And thirdly, you've got to look at his relationship with the beneficiaries, who could be family members or close associates. So those are the kind of layers you have to really look at in terms of a very general overview. One of the quick points I'll mention here is that obviously Mr. Petrov is a Russian national, UK sanctioned, and is a beneficiary. So of course, as you may know, that the assets in the trust belong to the trust and must be distributed by the trustees. But if Mr. Petrov is obviously sanctioned, the trustees cannot distribute the assets or any of the assets to Mr. Petrov, because doing so would be a breach. Of course, they can't make any funds or economic resources available to anyone who is designated, either directly or indirectly. I think from the UK perspective, the key thing to take away in terms of trust is that there is an expectation in the UK that a ban on trust services will come into force. It remains to be seen what services these will cover, but it could be the same as the EU. in that it covers providing management and fiduciary services to trusts and similar structures connected with Russian nationals. It's also hoped that the UK will provide some kind of exemption for trusts where the settlor or the beneficiary is a national or is lawfully resident in the UK. So that's the kind of UK overview on trusts.
Thank you, Zulfi. Carla, what's the Swiss position?
Well, like in the UK and the US, the notion of ownership and control must be assessed on a case-by-case basis. I think the decisive factor is whether the trust and its assets are under the effective control of a person, undertaking, or entity referred to in Article 28D of the ordinance. So 28D refers not only to designated person, but also to persons with a Russian link. In practice, like it was said before by my colleagues, you should look at Mr. Ivanov's potential control on the trustee and Mr. Ivanov's relationship with any ownership and management structures of the trust. You should obviously look at when the assets were transferred and Ivanov's relationship with the beneficiaries, who could be family members or close associates. If there is a risk, one should always assume that the trust is owned or controlled by a designated person or a person that would be mentioned in Article 28D, and clarify the situation. Now, something to look out for is that the Swiss ordinance establishes restrictions on the provision of financial services and sets a limit on the deposits that can be accepted from banks, companies, or entities established in the Russian Federation. SECO has, however, issued guidelines according to which this restriction does not apply to trusts that have a Russian settlor or a Russian beneficiary. So in our case, the Chaplin Trust, which is a BVI trust and that has a trustees in Cyprus, will still be able to distribute assets of the trust to the Swiss account of the beneficiaries. In my case, it's mainly also because the settlor is not Swiss sanctioned. And the consideration to be kept in mind is that Switzerland has aligned with the EU. I will let Salome explain exactly the details, but basically, services to trusts are not allowed in Switzerland since April 22. So you cannot have a registered office, an administrative address, or manage or provide management services to a trust if the settlor or beneficiary of the trust is a Russian national or a person residing in Russia or an entity established in Russia. It is also prohibited to act as trustee, nominee, shareholder. Exceptions exist if the settlor or beneficiary of the trust has a Swiss or a citizenship of a member state of the European Economic Area, or a resident permit of Switzerland or the EEA. In that respect, SECO has provided guidelines and has explained that if a trust has 4 Russian nationals, like in our case, and 1 person who is a citizen of both Russia and an EEA member state, the exception regime applies. So that's why in this case, it will be totally possible for the Chaplin Trust to operate.
Thank you very much. And Salome, let's have the EU perspective, please.
Sure, and I'll be very brief because actually it's very similar to what Carla just discussed. I think what is very relevant from the EU perspective is the criteria, which is not so much whether there's a designated person or not in the diagram. And I see that in the Q&A that have started to come up, like the situation needs to be carefully monitored as soon as there's a Russian national, either as a settlor or as a beneficiary of the trust. And so because of the prohibition that I set forth in Article 5M of the EU regulation, it is impossible actually for a EU incorporated entity to act as trustee and provide certain trust services to a trust that has a Russian national involved. So here in our diagram, Hanks Trust Limited based in Cyprus would be prohibited from acting for the trust. And in many cases, those services are actually essential to the operations of the trust. And so what the EU Commission has clearly said is that in that case, the only solution is the dissolution of the trust and the redistribution of the assets. So here in our case study, the good thing is that no one is EU sanctioned, so the distribution could occur. But of course, if there is a EU designated person, that triggers the considerations that we've discussed before, and the assets should be frozen immediately. Of course, there are derogations for dual nationals, but there is very little guidance as to how it would operate in practice. So it remains to be seen how it would, whether there would be more guidance from the EU and also how it would be treated by law enforcement. Thank you.
Thank you very much. Clearly a complicated area. So look, let's move on to our second topic, which concerns restrictions on particular sectors. The presence of a designated person in the corporate structure is not the only factor, as we know, that can trigger the application of sanctions. There may also be prohibitions on various sectors and services within respective jurisdictions. So here we're going to focus on trending areas per jurisdictions. For the next set of questions, with some variations, let's suppose there is no ownership or control of the relevant entities by DP. So Tom, we're looking at diagram 1 here again, if you can bring that up. My first question is to Eric. Eric, let's assume Hitchcock Inc., a US company, operates in the oil sector. Are there any restrictions on activities on this sector from a Russian sanctions point of view, and are there any exceptions?
Sure, there are some restrictions, and again, we're going to ignore the diagram here and assume there's not any ownership by Mr. Sidorov, because then the entity would be blocked, and then Hitchcock couldn't do anything. But that's no fun. So let's play with the facts a little bit. Yeah, there are restrictions on Hitchcock's importation of certain petroleum products, crude oil, petroleum fuels, liquefied natural gas, coal. So assuming here that Pushkin, being the parent, is operating in the energy sector of the Russian Federation economy, and that although Hitchcock's main line of business is in the US, that it is importing from its parent company, then there are restrictions. There is an executive order 14066, which was issued on March 8th of 2022, which would prohibit importations of those types of products I just described, and also investments in the energy sector of the Russian Federation economy, as well as facilitation of any of those prohibited activities. This is really important to note, this facilitation concept, because you find it in many different sanctions regimes, US sanctions regimes. But what it essentially means is that a US person cannot undertake any act which would allow two foreign persons to engage in that activity, which would be prohibited were the US person directly involved. So traditionally, that could be things like guaranteeing contracts, making business referrals, that sort of thing. So facilitation is an important concept to keep in mind anytime you're assessing these prohibitions. There's also exposure for Pushkin, although we say that in the diagram that is not designated. It certainly could be designated for operating in the Russian Federation energy sector. And then, of course, that would have a knock-on effect on Hitchcock, because if Pushkin gets sanctioned, then Hitchcock, being 100% owned, would likewise be blocked. There could also be export control restrictions as well. I won't dive into those. We just don't have time. But let's talk about the exceptions. There is a general license. And for those of you not familiar with that terminology, in the US, a general license means an open authorization, something you don't have to apply for, that allows certain importations or activities that would have otherwise been prohibited by Executive Order 14066, so long as those transactions were in place prior to March 8th. So it's effectively winding down these energy-related transactions. And I think that license expires on December 5th, I believe, of this year. Further, Lfac has issued guidance that non-US persons are not exposed to sanctions, blocking sanctions with respect to the engaging in activities which would be prohibited by Executive Order 14066. So, as with everything with sanctions, particularly US sanctions, is a fact-intensive exercise and analysis. But there are some restrictions in place, as I've highlighted, as well as some exceptions to be mindful of.
Thank you very much, Eric. Carla, let's look at Verbia SA, a Swiss company, and let's assume it operates in the asset management sector. Are there any restrictions imposed on activities in this sector? I also understand that there is a transfer limit between Swiss banks and any Russian persons. Sorry,
No. Well, thank you. As you know, yes, the answer is definitely yes, and it's very important since knowing that Switzerland holds 1/4 of the world's foreign assets under management. So yes, there are many financial restrictions that have been implemented. Among all of them, there is, of course, the obligation to freeze and report assets of a designated person. There are also restrictions and obligation of reporting on payments received from or on behalf of certain individuals or entities with Russian links. Regarding the restriction to provide certain services, we're talking about services to trust. I draw your attention to the fact that SECO confirmed that the usual banking or payment services, such as the provision of a bank account, the execution of payment or the exchange of currencies are permitted, and they are not concerned by the prohibition of the ordinance. Furthermore, regarding transfers to or from Russian individuals or entities that are not listed as designated person, one needs to keep in mind the following. It is prohibited under Swiss law for persons and institutions that accept deposits and grant credits on a professional basis if the total value of the deposits of the individual's bank, company, or entity exceeds 100K per person or institution to accept deposits from any Russian individual, any individual residing in Russia, banks, companies, entities established in Russia, and any entity established outside Switzerland or the European Economic Area of more than 20% ownership rights are held directly or indirectly by a Russian national or individuals residing in the Russian Federation. In addition, Article 21 of the ordinance, the Swiss ordinance, provides that persons and institutions that accept deposits or grant loans on a professional basis are required to provide SECO with a list of deposits exceeding 100K held by any Russian person, and an update needs to be given every 12 months. While a Russian individual who is not a designated person cannot receive deposits in excess of 100K, there are, however, no restrictions on the amount of the outflows. So if, for instance, if the Swiss assets of a Russian individual amounted 1 million when the sanctions entered into force, this Russian individual will be allowed, according to Swiss law, to transfer 950K to pay his creditors, and will then be allowed to receive only 50K as new deposits because of the 100K limit. Further to many questions received by SECO from the banks, SECO confirmed that transfers in excess of 100K between different accounts held by the same Russian individual within the same bank were allowed without the need of a special authorization. And finally, according to the Swiss ordinance, it is prohibited to sell securities denominated in Swiss francs or in the official currency of an EU member state issued after April 12, 2022. or units in collective investment schemes with exposure to such securities to any Russian national, any natural person residing in Russia, any bank, company, entity established in Russia. So there are many restrictions put in place, but these prohibitions do not apply. It does not apply if Swiss nationals of the European Economic Area or individuals holding a temporary or permanent permit in Switzerland or the EEA are involved. So basically, if you are double national, then the prohibition does not apply to you. This does not apply if you are binational with the UK or the US, obviously.
Thank you. Thank you, Carla. Salome, as PEC Limited operates in the EU and has a Russian parent, JSC Pushkin, given the EU's prohibition on carrying out certain professional services in relation to Russian persons, what's the impact on PEC Limited, and do any exceptions apply?
Sure, thank you, Aziz. Just before I answer your question, I see a question in the chat by Paul asking something about the redistribution of the trust assets under EU law, including to potentially designated persons. I'm not going to go into the details of this question, but I'd like to point out to the EU Commission's frequently asked questions as they were updated a week ago, because they specifically deal with this question and inform that assets that are redistributed needs to be frozen immediately if they were to reach designated persons. And I thought that was important to point out to our audience.
Sure.
With respect to sectoral restrictions in the EU, of course, there are many different sectors that are impacted by restrictive measures. I'd like to focus on one that is, in my view, very interesting, especially for the structure that we've presented in our case study, which is the prohibition on providing certain accounting and business consultancy services to Russian incorporated entity or Russian persons. So here in our situation, PEC Limited being conducting part of its business in the EU needs to comply with this prohibition. And the thing is, the way this prohibition was drafted is extremely broad, and it covers accounting, tax consultancy services, market management, human resources, like many different types of services to be provided to a Russian entity or connected to Russia. What we think is that initially this prohibition was mainly tailored to service providers, like big accounting firms, but because it's drafted so broadly, it actually impacts intra-group relationships. So in our case, PEC and its parent company, Pushkin, have many different communications that are part of their day-to-day business that may fall under this prohibition. So what is extremely important when companies identify that they have a parent entity incorporated in Russia is to closely scrutinize the services they are rendering to that entity, which may be very well part of their normal subsidiary to parent relationship, and assess whether they might fall under this prohibition. Because if they do fall under the prohibition, then these services need to be stopped immediately. And our recommendation in that case is to seek appropriate guidance from the relevant EU member state national authority. What is difficult in our situation is that the way the prohibition is drafted is that there are, of course, possibilities for derogations and exemptions, but they're very narrowly drafted. They only cover 2 instances, which are like humanitarian purposes and any activity, any civil society activity that contributes to the promotion of democracy. So it's very likely that none of the business activity would fall under that exemptions. Having said this, and this here is a recommendation because there's definitely no guidance supporting that, we think it is important to seek guidance with the relevant authorities, because we've seen that often EU regulations are later on amended or clarified when the implementation in practice is not ideal or does triggers situations that are not supposed to be covered. And so our recommendation would definitely be to seek authorization to conduct those services, also to show good faith and a proactive approach, and to avoid running the risk of being in breach of sanctions.
Thank you, Salome. Zulfi, as PEC Limited operates in the UK, do you have anything to add in relation to the UK's similar prohibition on the business management and consulting sector? I think that's Amendment 14 of the UK's Russia sanctions regulations.
Yeah, thanks, Aziz. I'll try and be very brief because I'm conscious of the time. So just obviously, as Salome has pointed out, the regulations, and in this case, Amendment 14 on professional and business services is deliberately drafted quite widely. I mean, it covers things like operational assistance activities, which could even be something as simple as provision of a correspondence address. So if we very quickly look at diagram 1 in terms of what we would have to consider, you would have to consider PEC and the services it provides in 2 directions. One is the services it provides to JSC Pushkin within the corporate structure. So this may be human resources or accounting related services. And you have to also consider the services PEC provides itself outwardly in terms of its business activities in the UK. Now, if they're providing it independently of Pushkin, then they should not be punished. But of course, there's very limited guidance on this point as well. So as Salome pointed out, you have to take it on a case-by-case approach and assess the situation, because guidance is quite limited in this area. We're expecting guidance to come soon. For example, there's no definition at the moment of what constitutes providing services for the benefit of the person. So for example, if PEC is providing a service to an independent third party that may ultimately benefit Pushkin, they could be prohibited from doing that, but we need more guidance on that. So I think the key takeaway point is that this is really a developing area, and we're perhaps seeing a move away from asset freeze and more towards sectoral trade restrictions. The upshot is really to seek legal advice if you're unsure as to whether you're providing a service that falls within professional and business services, i.e. business and management consulting, or if you're providing a service to anyone connected with Russia.
Thank you to our panelists for the contributions on restrictions. Let's move on to our third topic, which is licensing and reporting obligations. So you'll have heard our panelists have already touched on the subject of licenses. A license is required from a relevant jurisdiction's competent authority to proceed with what would otherwise be a prohibited activity. So let's look at these issues. Can I please ask our panelists, what are the key considerations when submitting a license application to the relevant authorities, and can and should the license be sought to simply seek guidance on whether an activity is prohibited? So can we kick off with Salome, please?
Sure, thank you very much, Aziz. And that actually gives me a good opportunity to address one of the questions that was asked in the Q&A function. The difficulty in the EU compared to the 3 other jurisdictions we're covering is that we're discussing EU regulations, obviously, but there is no one single entry point for obtaining that license and seeking that license. So it comes down to which member states you're seeking guidance from and where it makes more sense. So here, our recommendation would be to assess where the entity is doing most of its business, if it's not incorporated in the EU. If it's an EU incorporated entity, then to go to the authority of that country of incorporation, because that would have more link to the specific EU member state, and seek license for a specific service to be rendered. Now, each EU authority is not bound by the decisions of the others, and we've seen before that there were some contradictions between the various authorities. When the UK was still a member of the EU, they obviously had a position on, the impact of a designation onto other legal entities of the group, where France was considering that because of, corporate personality, there was some sort of a shield. And it took the EU Commission quite some time to issue its own opinion in June of last year, 2021, to answer this question and sort of side by the UK's position. Now it remains to be seen if other NCAs will continue to, to have their own views on that specific topic. So that is definitely one of the important elements to keep in mind. The other important element when reporting to, when seeking a license and seeking guidance is how to organize that when there might be a need to seek for a license in various jurisdictions. And there's a need for cautious coordination as well, especially as you do not want to be in breach in some countries and not in others, because you need to keep in mind that in any event, none of the authorities are going to grant a retroactive license. So if you seek a license for a specific service or activity, and this license is granted, then you're only covered for the future. But if you continue doing the business while waiting for the license, you could be in risk for the past before the license was authorized. And so that could trigger liability, including potentially criminal. I think those are the two key points that I would like to raise.
Thank you, Salome. Eric, can we have your views, please?
Sure, absolutely. So the basic points of what should go into an Lfac license application are obvious. Who are the parties to the transactions? What is the transaction for which you're seeking authorization? What sanctions program do you believe is implicated by the transactions? But the most important component, and one that I think is lost on a lot of applicants, particularly those who are not U.S. companies or who are filing on their own behalf without the benefit of U.S. counsel, is what is the U.S. nexus to the transaction? A very important point, because Lfac does not have the authority to license transactions which don't fall under its jurisdiction or which do not implicate its prohibitions, not its designation criteria, but its prohibitions. Thus, if there's no U.S. person involvement, no U.S. origin services, no U.S. origin goods or technology, there's no nexus to the United States, Lfac does not actually have the authority to authorize those transactions. You can, however, request guidance through the same procedural mechanism. It looks identical to a license application from Lfac to determine whether or not the transactions are sanctionable, meaning are the parties exposed to a sanctions designation as a result of engaging in the transactions. Here is what many years of experience has taught me. You will get in a few years, Lfac will send you a very short letter that says, well, here's what the law says, and to the extent the facts applies, you could or you could not be subject to sanctions, which is immensely unhelpful. So what many parties do to obtain guidance is they manufacture U.S. jurisdiction for purposes of the application. In other words, they say, this is the course of dealings we want to engage in. It's not entirely certain whether a U.S. party will become involved in or not at some point as we're conducting these transactions. For example, there could be a foreign branch of a U.S. bank that needs to process a financial transfer related or financial payment related to the transaction. So to the extent that U.S. persons are involved, we seek authorization for U.S. persons to engage in any transactions which are ordinarily incident or necessary to carry out these transactions, which are otherwise occurring outside of U.S. jurisdiction. That will get at least an answer for you as to whether or not Lfac will license the U.S. person's involvement. Well, what does that mean for you as the non-U.S. person with the sanctions exposure? It means two things. One, if Lfac says that they will not allow U.S. persons to participate in the transactions, there's a good sense that it's potentially sanctionable, that they may be willing to impose a sanctions designation. Or two, if they say that, okay, we will authorize U.S. persons to engage in the transactions, then what it says, and this is consistent with other OFAC guidance, is that it will not be sanctionable because OFAC's general policy, and they've issued some guidance on this, is that they will not sanction parties for engaging in transactions which U.S. persons themselves could have participated in or would have received a license to participate in. So those are the basic points on the license. And then if you're going to request guidance, there's a right way and a wrong way to do it. One last note, expect very long waiting times with OFAC. I always tell clients that the backlog at OFAC is immense. And we're talking months, sometimes years before an application will be responded to. Notwithstanding those caveats, clients usually come back after a few weeks and say, where's the license? I'm just once again reiterating for public consumption, it takes a long time to get a OFAC license in most circumstances.
Thank you, Eric. That's extremely useful. Carla, can we have your views, please?
Yes, of course. Well, in Switzerland, there's no much guidance. Like in other jurisdictions, there are strong expectations from SECO to collaborate and provide all relevant information. So you want to be as thorough as possible. In theory, you can definitely ask questions to SECO by sending an email if you want to seek guidance. However, most of the time, if it's only to seek guidance, or either they don't respond or it takes them a lot of time to respond. An applicant should never assume that an authorization will be granted or engage in any activities prohibited by Swiss sanctions until an authorization has been granted. The timeline for the authorization to be granted by SECO varies from each case and depends on the complexity of the matter. In simple cases, it can be obtained in 2 or even 2 or 3 days. In very complex cases, it could take several months for the authorization to be granted, since the SECO will carry out some research and consult other departments, sometimes foreign agencies as well. But obviously, it also depends on what is at stake. One recent example is the sale of Sberbank Switzerland AG that was closed early September, and it was a designated entity to a Geneva company called M3 Group Holding SA, and FINMA and SECO worked together. They lift the trading and payment ban imposed on Sberbank. They allowed the sale. Everything was done within 3 months. And just because there were many things at stake and creditors needed to be paid. So it is possible, but you obviously need to be as thorough as possible. And usually when payments include payments going from Switzerland to other countries, they will collaborate with, and they will coordinate their actions with foreign agencies. And this allows me, if you allow me, as is, to treat question 1 in the Q&A. So in my experience, they want to coordinate with foreign agencies, and banks in practice will not make payments if they are not reassured that this will not comply, that this will comply with foreign law as well. So yes, I will definitely, I don't think that the initial approval for one agency will be sufficient. You will need to obtain authorization from foreign agencies as well, and force the authorities to coordinate their action.
Sure, thank you very much. Zulfi, very quickly, if I may, the UK side of things.
Yeah, okay, very quickly. Just a couple of things. Overall, OFSI for licenses when it comes to financial prohibitions, and Department of Trade for trade licenses. The other factor is when it comes to legal fees, you've got to be mindful that you'll need a separate license for payment of fees. You're able to provide the advice, but you're not actually able to be paid for it. But just an FYI on that, there was a recent webinar with the OFSI director where there was a suggestion that there might be a general license for the payment of fees, which might be pleasing to law firms. Just a couple of quick things on considerations when submitting a license application. In terms of services, you've got to understand really the service that's being supplied, who it's being supplied to, and what the purpose is. So you've got to have as much supporting documentation as possible, and consider obtaining witness statements and representations from individuals in the company. Again, the same considerations would be taken into account when applying for an OFSI license. One quick thing I must stress is when it comes to trade, an applicant should not assume that a license will be granted or engage in any activities prohibited by trade sanctions until a license has been granted. So basically, if you come across an activity that you believe is prohibited, stop the activity.
Thank you. So let's move on to sanctions, breaches, and reporting obligations. So I want to ask the panelists if they can please consider the issue where if you've not obtained a license and you consider you breached sanctions prohibitions, what are your options? And when reporting breaches to the authorities, what factors should be considered in your analysis and submissions? Short answers, please, if I may. So starting with Carla, please. You got your microphone. Yep.
Yes, sorry. So, I mean, obviously it's a case-by-case basis, but you should definitely, I mean, my initial thought would be you need to instruct counsel, you need to establish the facts, and yes, you need to report and collaborate with SECO as much as possible in order to avoid try to avoid any criminal liability. So basically that would be my advice.
Okay, Zulfi?
Yes, you've got to, if you're a company, you've got to consider a quick response strategy. You can either do nothing, which is not advisable, or you can instruct counsel to independently assess whether a breach has taken place, and then of course engage with the authorities. I think a couple of the key factors for OFSI guidance is disclosure should be full and prompt, the level of cooperation and the interim measures for compliance purposes that have taken place. So very quickly, from a practical point of view, if you're a company, you've got to notify board of directors, set up an audit trail covering post-breach discovery communications, and retain all relevant documentation that might be useful for the lawyers and also when engaging with the authorities.
Thank you. Eric?
Sure. Assuming you've identified a violation of sanctions, you need to determine whether or not there was willful conduct, meaning it was the violation of a known legal duty, because that'll determine whether the conduct is potentially subject to criminal penalties or civil penalties, and of course changes the analysis as to whether or not a company should open the door by reporting it to Lfac. So that's one consideration. Another consideration is how pervasive were the violations? Was it a pattern of conduct that occurred, or was it a one-off? Was the activity which led to the violation remediated? Have steps already been taken to address the problem? What is the likelihood that Lfac would become aware of the violation? Was it something that happened internally? Or is it something that happened through, let's say, a financial institution which may report it? All of these are factors in determining whether to open the door and disclose the violation. In terms of factors outside of those to look at, Lfac has in Appendix A of Part 501.31 Code of Federal Regulations set out their enforcement guidelines, which highlights 13 factors, the general factors affecting administrative action, which kind of guide Lfac through both what its enforcement response should be in any given case, as well as whether the enforcement response should be aggravated or mitigated in light of the particular circumstances. So that's my very quick and concise answers on that.
Very concise. Thank you, Eric. Salome.
Thank you. I will be as brief as the others. All that was discussed before is definitely relevant when reporting a breach to the EU. Difficulty here is that each EU authority will have a different view on how to take into account that spontaneous and proactive disclosure. There is no guidance as to how this would be treated as a mitigating factor, but our general recommendation would definitely to be proactive, to document every steps, establish a very good pepper trail, and then liaise with the relevant authorities. Also, because what you don't want to face is a situation where you report, for instance, to OFSI, but you fail to report to the relevant EU authority, and that authority becomes aware by OFSI and intra-authority communication, because what you want is to be the one company deciding when you're approaching authorities so that you can make the best out of it. And that leads me to a very specific example where you need to be aware that in company structures, there are other professions with reporting duties, including auditors, for instance. And so you don't want them to become aware of a breach and having to report to their national authority that such a breach occurred before the company proactively took the relevant steps, because then you lose all the benefit of running an internal investigation and potentially implementing the remedial actions that would help when approaching the authorities. So in a nutshell, definitely seek legal advice and be the owner to the extent possible of the timing of such reporting, but sooner rather than later so that others don't do it for you.
Okay, thank you very much. Just going through the going to the last subject area, which is hot topics, trending areas in enforcement landscape. Can I ask that each panelist advise on one trending issue, please, starting with Eric?
Sure. I think the issue of the day is really seizures and forfeiture for sanctions violations. And what's really important to note in this space is that the sanctions regime, most sanctions regime, including that targeting Russia, has what we call causation liability, which means if as a foreign party, you cause a U.S. person to engage in a violation, you as the foreign party could yourselves be liable. So why is that important with respect to seizures? Well, that also extends to the property involved. So for example, if you are a blocked person and you are making a payment for your yacht and that payment crosses a financial institution in the US, there's a potential predicate for seizure of the yacht insofar as property related to that yacht, there's a blocked interest with respect to. And so look for the U.S. Department of Justice to become very active in this area. There's a klepto capture task force that's been set up, and they're very keen on identifying assets involved in sanctions evasions or which might have derived from other violations of U.S. law for forfeiture.
Sure. Thank you. Thank you. Salome?
Sure. I think what we are definitely monitoring in the EU is the enforcement of any breach of sanctions. So we've seen, for instance, in Germany that the first raids have occurred targeting a Russian oligarch and also those associated to that oligarch suspected of aiding and abetting circumvention of sanction. And this is of significance because enforcement action in relation to sanctions matter are generally rather rare in the EU, so that's definitely something we are closely monitoring. Right now, this does not so much trigger consequences for regular business activity because those are very specific situations, but we are definitely closely monitoring how sanctions impact EU companies and how they can be in breach and what are the sanctions they face and what is the liability that they may face.
Thank you. Zulfi? Yeah, the one sort of trending area is from the UK side is, I think, the recent NCA arrests of potential sanctions enablers. So you can see what the NCA are trying to do in terms of criminal enforcement. Perhaps they're looking to target enabling or facilitation offences. So that's something to watch out for, and any potential prosecutions on that around the corner.
Thank you. And finally, Carla?
Trending areas are many, but one of the trending areas is definitely enforcement, and a number of important themes are emerging in terms of sanction compliance, including a patchwork approach across jurisdictions and concerns around the individual liability for sanction compliance. So, I think collaboration and coordination between different approach, different jurisdictions, different interpretations will definitely be a thing to look out for.
Excellent. Okay. As we've been going along, we've answered some of the questions. Are there any question that the panelists want to answer. We only have a few minutes, perhaps.
Yeah, Aziz, I can pick up on one of Paul McGrath's questions.
Sure.
I don't know if he's still there, but just so I understand, Paul, in relation to the trust question, very, very quickly, if there is a beneficiary that's designated in the trust, there could potentially be an issue for the trust. So there's one factor is the distribution and then the trust. But of course, I think we would then have to look at the actual control that that person has over the trust and whether they are exercising that control in relation to the distribution of the assets to him. I think the answer to that is yes, there is probably an issue for the trust that they would have to consider. The second question, sorry, I'll very quickly read it. I think it's also from Paul.
In the meantime, Zulfi, maybe I can address one of the other questions from Najam Sakib, who asked about, changing the situation if GSC Pushkin was owned by 40% by 2 EU designated persons. How would we assess? I think what is really important to keep in mind is that the first question from an EU perspective is there ownership? Is there more than 50% by a designated person, either alone or in aggregate? If yes, then asset freeze measures extend to the entity. If no, then the second question is there control? And that I refer to the guidance that we've mentioned to establish control. And if there is such control, then the assets of that controlled entity should also be frozen, despite not being directly listed on the EU sanctions list.
Okay, Zulfi?
Yeah, I can pick up on Paul's. I don't know whether Paul can clarify, but in terms of obviously the reporting obligations, as you'll know, they'll apply to relevant firms. Yeah. So if you're talking about us as reporting, if we understand that there's a designated person, I would have to check this, but I'm not sure that applies to us as the firm. However, if of course a client is someone that is a relevant firm and they're concerned about reporting obligations, then I think the answer to that is yes. You would the best thing to do would be to warn them in advance of any investigation. But I think the factor there is on the relevant firm and who is the relevant firm.
Okay, so I'm sorry to say I must bring matters to a close now. We certainly haven't been short of subject matter, and I would like to thank the panelists for their expert contributions. I'm sorry we've not had time to answer all the questions posted, but please feel free to contact me or our panelists, and we will answer your queries. But now we have come to an end, and it only remains for me to say thank you again, and goodbye.